A unanimous Supreme Court ruling just changed what police can do at your front door, and most gun owners still do not understand it. If you think a welfare check always lets the government walk in and take your guns, what I'm about to tell you may shock you. And quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a massive legal mistake when police show up at your home. Hit that button now, because gun law changes fast, and the people who learn late usually pay the highest price. Here's what just happened, and why this case matters so much to you. The case is called Caniglia v. Strom. It was a 9-0 decision. Not 5-4, not 6-3. Every single justice agreed on the core point. Police do not get a free pass to enter your home without a warrant just because they call what they are doing community caretaking. That phrase sounds harmless. It sounds like helping. It sounds like safety. But here's the crazy part. Lower courts had started treating that phrase like a magic key. If officers said they were not investigating a crime, but were just checking on someone's welfare, some courts let them enter homes and seize property anyway. And in this case, that property was firearms. Let me break the facts down for you in plain English. Edward Caniglia had an argument with his wife. During that argument, he put a handgun on the table and said something like, "Shoot me and get it over with." His wife left and stayed at a hotel. The next morning, she could not reach him, so she called police for a welfare check. Officers went to the house. They spoke with him outside. They got him to agree to go to the hospital for a mental health evaluation. But there was an important detail here that a lot of people miss. He agreed on the condition that they would not take his guns. After he left, officers went into the home and seized his firearms anyway. Now stop and think about that. Imagine you're standing on your porch. You're upset. You agree to leave peacefully. You believe your home is still protected. Then, while you are gone, officers go inside and remove your lawfully owned guns without a warrant. Most people think, well, if it was for safety, maybe that's allowed. But the Supreme Court said no, not under a broad community caretaking theory. And this is where it gets interesting. The lower court had relied on an older car case. That older case said police sometimes do community caretaking work involving vehicles, like dealing with disabled cars or public safety on the road. But the Supreme Court said homes are different, very different. Your car on a public road is not your house. Your driveway is not your living room. Your front porch is not your bedroom. The Constitution gives your home the highest protection. That is the first big takeaway. First thing, this ruling was a major Fourth Amendment win. The Fourth Amendment protects you from unreasonable searches and seizures. In simple terms, it means the government usually needs a warrant before entering your home or taking your property. The court said that rule does not disappear just because police use a nice-sounding label. Second, this ruling matters for the Second Amendment too, even though the court did not create some brand new gun test in this case. Here's what most people get wrong. The court was not saying every gun seizure is illegal. It was saying police cannot use a broad caretaking excuse to get around the warrant rule inside the home. So if your lawful firearms are in your house, this decision strengthens the wall protecting them from being taken without proper legal authority. That is why the title sounds so dramatic. It changed Fourth Amendment rules directly. And it changed the real-world protection around your gun rights indirectly, because the government cannot so easily separate you from your firearms inside your own home. Now think about a real-life scenario. Imagine your neighbor hears you yelling after a family argument. Police show up for a welfare check. You step outside. You say you are fine. They do not have a warrant. They do not see an active emergency inside. Under this ruling, they do not get to say, "We're just caretaking," and then walk through your house looking for guns to take. That matters a lot. But wait, there's something even more important. This ruling did not erase every exception to the warrant requirement. And this is the part that shocked a lot of people online, because many videos made it sound like police can never enter without a warrant again. That is not true. If there is a real emergency, like someone bleeding, a person screaming for help, or facts showing someone inside is in immediate danger, officers may still be able to enter under the emergency aid exception. That difference is everything. Community caretaking is not a blank check. Real emergency aid is still a recognized exception. If you miss that distinction, you will misunderstand the whole case. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it, because knowing the law before a police encounter is a lot better than learning it after one. Now let me explain why this matters beyond one man in one house. This case exposed a growing problem in America. Government power expands one exception at a time. It rarely happens with flashing lights and dramatic speeches. It usually happens with words that sound reasonable. Public safety, welfare check, caretaking, temporary seizure, emergency concern. Most people hear those words and lower their guard. But the Constitution was written for moments exactly like that. Here's the second major point. The home is still special. The court made that crystal clear. What is allowed with a car does not automatically carry over to your house. Why? Because the home has always had stronger protection in American law, the justices basically said you cannot take a rule built for impounded vehicles and stretch it into your living room. That sounds obvious, right? But for a while, some courts were doing exactly that. Here's a hypothetical example to explain this. Say your truck is disabled on the roadside. Officers may have more flexibility to secure it, inspect dangerous items in it, or protect the public around it. Now compare that to your locked home. There, the Constitution expects a much stronger reason before government crosses the threshold. The Supreme Court said that line still matters. Now, this is where it gets interesting. Some people heard about this ruling and assumed it means your guns are untouchable. That is not true either. If police have a valid warrant, different story. If there is a true emergency, different story. If state law creates a process for a judge to order temporary removal under certain conditions, that brings in a different legal fight. So do not walk away from this thinking, no one can ever take my guns now. That is not what the court said. What the court did say is powerful, though. It rejected the idea that police have an open-ended license to enter homes and seize property just because they are performing a non-criminal civic function. In plain English, they cannot just say, "We meant well," and skip the Fourth Amendment. And that matters, because welfare checks can turn into gun seizures fast. Have you ever wondered how a simple call can snowball? One person is worried. Police arrive. Tension is high. They see a gun safe, a holster, or ammo box. Suddenly, what started as a check on your well-being becomes a firearms issue. This ruling tells courts to ask a hard question. Where was the warrant, and what exception really applied? There is another reason this decision hit both amendments in the real world. Gun rights do not mean much if officials can bypass your privacy rights to get to your guns. Think about that. The Second Amendment is about the right to keep and bear arms. The Fourth Amendment is about security in your home and property. When government action targets firearms inside the home, those two rights start working together. That is why this case matters so much to law-abiding gun owners. It reminds courts that constitutional rights are not separate little boxes. Sometimes one amendment protects the conditions that make another amendment meaningful. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's what most people still get wrong. They think Caniglia means any welfare check entry is illegal. That is false. In fact, more recent cases have made clear that officers can still enter without a warrant when they have an objectively reasonable basis to believe someone inside needs immediate emergency aid. So if you are hearing people say, the Supreme Court ended welfare checks, that is simply not accurate. Let me make that practical for you. If police are responding because someone inside may be actively injured, may have just attempted suicide, or may be in immediate danger, courts may still uphold entry. But if there is no real emergency, and police are relying on a vague caretaking theory, Caniglia is the case that says, no, that is not enough. This is the part nobody's talking about. The biggest battle now is not over whether the Constitution matters. It is over how facts get described. Was it really an emergency, or was it just concern? Was there an immediate threat, or just uncertainty? Were officers trying to save a life, or were they using a safety label to avoid getting a warrant? That is where future cases will be fought. And if you own guns, you need to understand that difference before you ever face it. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first. Click subscribe, because the next case that drops could affect what happens to you during a traffic stop, a home visit, or a so-called welfare check. Now let's talk consequences, because this is where the rubber meets the road. If you don't know this case, here's what could happen. You could believe officers have more power than they really do. You might consent when you do not have to. You might hand over information too quickly. Or you might make the opposite mistake and assume police can never act without a warrant, then misread a true emergency situation. Both mistakes are dangerous. First, do not assume every request is lawful just because it sounds polite. We just want to make sure everyone is okay, can be sincere, but it can also open the door to serious constitutional issues. Second, do not confuse consent with compliance. If you voluntarily let officers in, that changes everything. A lot of people lose good Fourth Amendment arguments because they said yes in the moment. I'm not telling you to be rude. I'm telling you to understand that your words matter. Third, do not assume your gun rights stand alone. If the government can get into your house more easily, your firearms become easier to seize. That is why this case matters so much, even though it was framed as a search and seizure case. Imagine you are at home after an emotional night. A family member calls police out of concern. You step outside, calm and cooperative. If there is no active emergency, Caniglia gives your side a strong constitutional argument against officers entering your house just because they say they are helping. That can make the difference between your guns staying secured in your safe and getting hauled away. But here's the crazy part. The same system that protects you can also be used against you if the facts are bad enough. If officers have strong signs of immediate danger, courts may approve entry under emergency aid. So the lesson is not blind trust, and it is not blind defiance. The lesson is precision. Know the rule. Know the exceptions. Know that words like caretaking, emergency, and consent can decide the outcome. When I found this out, what stood out most was how narrow and how powerful this ruling was at the same time. Narrow because it did not wipe out every exception. Powerful because it slammed the door on one broad excuse that could have swallowed the Fourth Amendment inside the home. That is why the 9-0 vote matters. In a divided country, every justice agreed your home cannot be treated like just another place for flexible government entry. That is not a small thing. That is a constitutional line in the sand. This information could literally expire after the next major case narrows or expands these rules. Subscribe now because the next video explains exactly what you need to do when police ask questions during a gun-related welfare check. And missing that one could be a costly mistake. So here's the bottom line. Caniglia v. Strom did not create unlimited gun immunity, and it did not end emergency entries. What it did do was shut down a broad theory that police could use community caretaking as a reason to enter your home and seize your firearms without a warrant. That is a major Fourth Amendment protection, and for gun owners, it is a real-world shield for your Second Amendment rights too. If this helped clear up the confusion, subscribe right now and share this with one person who owns a firearm and still thinks police can always take guns during a welfare check. And one final reminder, laws change, facts matter, and every case turns on details. So this is general educational content, not personal legal advice.